Hello everyone, this is Urvashi Chauhan. Welcome to Courts Today by Livelaw, where we bring you the latest developments from all courts across India. Let us start. Starting with an important update from the Supreme Court. The validity of extending period of SC/ST reservations in Lok Sabha and state assemblies has been challenged, and the Apex Court has decided to hear the matter in November this year. As you already know, that the SC and ST reservation system in India is a government policy aimed at addressing historical injustices, social inequalities and discrimination faced by marginalized communities. Article 334 of the Constitution provides for the same. In its original form, this provision declared that reservations for SC/STs and Anglo-Indians in Lok Sabha and the state assemblies will cease to have effect after 10 years from the commencement of the Constitution, which meant in 1960. But 1960 is long gone, and the reservation still continues due to various constitutional amendments by which it was extended again and again. The petitions were filed in the year 2000, challenging the 79th Constitution Amendment Act 1999, which extended the political reservations by another 10 years. Then in 2019, the 104th Amendment to the Indian Constitution was made, and this extended the time limit for terminating SC and ST seats in the House of Commons and the state legislatures by another 10 years. This amendment, however, put an end to reservations for Anglo-Indians by not extending its period. This amendment came into force with effect from 25th January 2020. Today, the Supreme Court has decided that a bench comprising CJI D.Y. Chandrachud, along with Justices A.S. Bopanna, M.M. Sundaresh, J.P. Pardiwala and Manoj Mishra will adjudicate upon the validity of this 104th Constitution Amendment Act. The bench, however, clarified that it will not go into the validity of the previous extensions given. The proceedings shall be listed on 21st November this year. Stay tuned with Livelaw. The next update is regarding the menace of increasing stray dogs attacks in Kerala. Earlier this year, the Kannur District Panchayat had filed a plea for a direction to euthanize suspected rabid or extremely dangerous dogs in the district. In the application, the State Commission had recommended culling or confinement of stray dogs to tackle the problem. In a recent affidavit, the Kannur District Panchayat has told the court that an estimated 30 stray dog bites are being reported in the district every day, and that between January 2021 and July 2023, 465 children in the district were injured in stray dog attacks. That the Kannur Panchayat had started 4 animal birth control centers, out of which 3 centers have become defunct due to public outrage and a lack of funds. The Panchayat has stated that killing stray dogs in some humane way is the only solution to the problem, with castration, use of chemicals, etc. being other options to control the dog population. It has also been stated that there is no conflict between the provisions of the Prevention of Cruelty to Animals Act with the powers to destroy stray dogs under Panchayat Raj Act or Municipality Act. The Supreme Court will hear the matter tomorrow. Stay tuned with us. In the next update from the Supreme Court, it has today decided to commence hearing the batch of petitions challenging constitutional validity of Section 6A of the Citizenship Act 1955 from 17th October this year. The bench comprising CJI D.Y. Chandrachud, along with Justices A.S. Bopanna, M.M. Sundaresh, J.B. Pardiwala and Manoj Mishra had taken up the matter today to pass procedural directions. Let me tell you briefly about this matter. Section 6A of the Citizenship Act was inserted by way of an amendment in 1985 in furtherance of the Assam Accord. For those of you who might not know, let me tell you that the Assam Accord was signed on 15th August 1985. It was a landmark agreement between the Government of India and leaders of the Assam movement. It aimed to address issues related to illegal immigration and protect the rights of indigenous population in the state of Assam, who had witnessed a significant influx of people from Bangladesh and other regions. It provided that the people who entered India between 1st January 1966 and 25th March 1971 and had been living in Assam would be allowed to register themselves as citizens of India. But Assam Sanmilit Mahasangh, a Guwahati-based civil society organization, challenged this section in 2012. It argued that the section was discriminatory, arbitrary, and illegal insofar as it provided for different cut-off dates for regularizing illegal migrants who entered Assam and the rest of India. It sought the court's indulgence in directing the concerned authority to update the National Register of Citizens, that is the NRC, by taking account of the electoral rolls prior to 24th March 1971. Eventually, other organizations from Assam filed petitions challenging the validity of this section. This important issue will be taken up by the Apex Court starting from 17th October. Stay tuned with us. Significantly, the Supreme Court has reiterated the paramount importance of eyewitness accounts in criminal trials. The court has emphasized on the importance of ocular evidence over the opinion of medical experts. The Apex Court has underlined that eyewitness testimony, even if not detailed in every aspect, holds substantial weight in establishing the sequence of events. In this case, the Supreme Court bench, comprising Justices Aniruddha Bose and Justice Bela M. Trivedi, was hearing an appeal against a Gujarat High Court judgment that overturned the acquittal by the trial court. The case revolved around the brutal killing of Jayanti Bhai, who succumbed to knife injuries sustained during the incident. The trial court had initially acquitted all three accused persons, primarily based on medical evidence. The High Court in appeal reversed the acquittal and held the appellant liable. Against this, the appellants approached the Supreme Court. The counsel for appellants, Advocate D.N. Ray, referred to discrepancies in the manner in which the knife blows were allegedly inflicted and in identification of the weapon used in the assault. He strongly contended that the medical evidence presented during the trial clearly indicated that the knife seized as evidence could not have caused the fatal injury sustained by the deceased. The court, however, pointed out that the trial court had placed undue emphasis on relatively minor contradictions in witness statements while ignoring the overall testimony of prosecution witness. The court said that even if, in the opinion of the autopsy surgeon, there was a mismatch of the knife with the injuries caused, the doctor's evidence cannot eclipse ocular evidence. The court referred to various precedents and observed that it was common for different witnesses to provide slightly varying accounts of details. But unless these contradictions were of substantial significance, they should not be used to reject the entire body of evidence. In light of this, the Supreme Court upheld the conviction and dismissed the appeal. To read in detail about this case, do visit livelaw.in. In the next update, the Delhi High Court today passed an interim order protecting the personality rights of Bollywood actor Anil Kapoor and restrained various entities from misusing his image, name, voice, or other elements of his persona for monetary gains without his consent. Let me tell you here, personality rights are the legal rights that individuals have to control the commercial use of their name, image, or other aspects of their identity. These are often associated with celebrities and public figures, but they can apply to anyone. The Bollywood actor in this case had filed a suit seeking to restrain various entities, including John Doe's, from violating his personality rights by using his name acronym AK, nicknames like Lakhan, Mr. India, Majnu Bhai, and the phrase Jhakas, and his voice and images without his permission for commercial gains. He also sought protection against the misuse of his personality rights through the use of any technology, including artificial intelligence, deepfakes, GIFs, etc. Justice Pratibha M. Singh today passed the interim injunction order and restrained the defendants and other unknown persons from disseminating various videos and directed that the same shall be taken down immediately by all internet service providers. While dictating the order, Justice Singh observed, while there was no doubt that free speech about a person in the form of satire and writings is protected, and also criticism which can be genuine, However, when the same crosses the line and results in tarnishment or jeopardizing the individual's personality, the same would be illegal. The Karnataka High Court today adjourned hearing in the petitions moved by news channel Aaj Tak and its consulting editor Sudhir Chaudhary for quashing the FIR registered against them over alleged communal coverage of the state's Swavlambhi Sarthi scheme, whereby subsidy is given to religious minorities for purchase of vehicles. Single bench of Justice Hemant Chandragaonkar extended interim protection granted to Sudhir till 3rd October, that is the next date of hearing. Let me tell you, the FIR states that on 11 September in a news program, Chaudhary claimed that Karnataka government was providing the scheme only to the minorities and not to the non-minority Hindus, and that it was practicing minority appeasement in the state. Karnataka Minister Priyank Kharge refuted this report on social media and said that the scheme was started by the previous government. In another update, a Delhi court has refused to dismiss the application for acquittal by Rajasthan Chief Minister Ashok Gehlot in a criminal defamation case filed by Union Minister Gajendra Singh Shekhawat in relation to the alleged Sanjeevani scam. The complaint case was filed by Shekhawat alleging defamation by Gehlot. Shekhawat had alleged that Gehlot called him and his family members, including his deceased mother, accused in the alleged scam, and that during press conferences, Gehlot claimed that the allegations against Shekhawat stand proved. Gehlot had filed an application seeking acquittal in the case, citing Shekhawat's absence at the court on 2 previous occasions. But Additional Chief Judicial Magistrate Harjeet Singh Jaspal of Rouse Avenue Courts dismissed the application, stating that though Shekhawat's conduct was of immense significance, but an absence on mere 2 dates, and that too when he was represented by his counsel, could not be called a justifiable ground to exercise the discretion and acquit Gehlot. As you know, that Corp, formerly known as Twitter, has filed an appeal before the Karnataka High Court against a single bench decision to dismiss its challenge to the centre's blocking orders. A division bench of Justice G. Narinder and Justice Vijay Kumar A. Patil today continued to hear the appeal questioning blocking orders issued by the Ministry of Electronics and Information Technology under Section 69A of the IT Act. The court today asked the union government to respond whether it would reconsider the blocking orders passed by it, directing Corp to block user accounts. This was on the suggestion of senior advocate Sajan Puvaiya, appearing for Corp, who submitted, though the company had blocked the accounts and would remain status quo until further orders, the fact remained that the centre's blocking orders were not reasoned. He thus urged that the orders be reviewed by the government. Accordingly, the court remanded the matter back to the Secretary, Ministry of Electronics and IT, and fixed the case for 27 September, awaiting centre's stand. Also, as you know, the single bench had earlier imposed a cost of 50 lakhs on the company, which they challenged in the appeal. During the hearing today, the court wondered if the single bench was justified in imposing such costs, especially in absence of any provision in this regard. And lastly, an update on the CLAT exam. As you know, that a PIL has been filed by a law student seeking the conduct of CLAT UG 2024 not only in English but also in other regional languages mentioned in the 8th schedule of the Constitution. Bar Council of India has also supported this by saying that conducting CLAT in regional languages will give opportunities to more citizens to pursue law as a career. But the consortium of NLUs, which conducts the exam, has expressed reluctance in conducting it in regional languages. It has said that translating AIBE exam is easy, but CLAT exam involves much more issues in translation. Well, now, the National Testing Agency has informed the Delhi High Court that it is in a position to conduct CLAT UG 2024 in regional languages. NTA has, however, said that support of the consortium of NLUs or any particular NLU will be of great assistance to it for smooth and fair conduct of the exam. The agency has added that the exam can even be conducted in computer-based test mode like JEE and CUET. The matter will be heard on 6th October before a division bench of Chief Justice Satish Chandra Sharma and Justice Subramaniam Prasad. Stay tuned with us. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on LiveLaw. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.